think we're going to get started now. Thanks so much for coming today. I think we're in for a real treat. I'm going to keep introductions very brief because I think everyone would love to hear from our panelists more than they'd like to hear from me, even though I could go on. So first, let me introduce our panelists today. I'm Jeannie Fromer, by the way, a professor here at NYU. This is over here at the end, we've got Simon Tam, who's the founder and bassist of The Slants, and is going to tell us about his journey in trying to trademark his band name, and all the way up to the Supreme Court, where we're waiting for a decision on whether he can. And then next to him, we've got Lee Rowland, who's the Senior Staff Attorney of Speech, Privacy, and Technology Project at the ACLU, and a longtime friend of NYU. And then on the other side of me, we've got Cecilia Chang, longtime New Yorker until very recently, went down to DC and is now the Director of Litigation at Asian Americans Advancing Justice. And so we're going to have a conversation about this case, about trademark law, about the First Amendment, about the implications of what might happen in this case. But I wanted to start out with Simon and your story, basically, about what led you to choose this name for your band, what made you decide to file an application to register your trademark, and what happened. So your personal story here.
Sure.
Yeah.
And I'll try and keep it brief because this is like over about a decade of my life, maybe more. Back in 2004, I was watching a film, Kill Bill. I'm guessing many of you have seen it, Quentin Tarantino film. And there's this very iconic scene in the film where a woman named Oro Nishi walks into a restaurant. And to anybody else, it's just another trademark Quentin Tarantino scene of where people are walking in and there's music playing. It was at that particular moment that, while in the movie it kind of represents a shift in the storyline and the plot line, and as it does in all of his films, it actually created a shift in my own personal life. It struck me in such a profound way, I couldn't really figure it out why. Like, I just paused the film, I thought about it. And that's when I realized that it was the first time I had ever seen an American-produced film that showed Asians as cool, confident, and sexy. You imagine growing up your entire life in the country you were born and never seeing any representation of that in mainstream media and entertainment at all. And so I started thinking more about my own art, music, which is the art form that I chose to drop out of college, even though I was in a full-ride scholarship with a double major on. Not something I recommend to any of you to do, but and the same art that I moved across the country away from all of my friends and family for. And I thought about, at the time, this is 2004, I thought, there's over 17 million Asian Americans. How come I couldn't think of a single one that graced the cover of Rolling Stone or that was being played on the Billboard charts or on the radio or TV or anything like that? And at that moment, I decided that something needed to change. Now, so I wanted to start a band that was about representation, that we could address some of the experiences that I had faced as an Asian American growing up here. I didn't know it at the time, but I moved to what people call America's whitest city. So finding people to join this band was a little bit of a challenge. But I knew, Band 101, you gotta have a name. So I started asking friends around and saying, hey, what do you think all Asians have in common? And they would immediately respond with slanted eyes. And I just thought it was so interesting because I said, slanted eyes, number one, it's not true. Not all Asians have slanted eyes, and Asians aren't the only people on this planet that have any kind of slant to their eyes. But number two, it'd be a really cool way to pay homage to Asian American activists who'd been engaged in this work of reappropriation, of reclaiming, kind of stigmatizing slurs and labels, and using it as forms of self-empowerment instead. And the more I thought about it, the more I thought, this could be our own perspective, our own slant on life as Asian American musicians, while having a band name that was really cool in 70s post-punk kind of style. So I thought it was perfect. We launched in 2007 was our first show. Started playing all across the country and very quickly got covered by nearly every Asian American press out there because there was such a hunger in our community for any kind of representation. And then 2008, we got our first big national splash with NPR, All Things Considered. They did a story how we were taking on stereotypes, turning them upside down while building a geek army. Because at the time, we were playing anime conventions. And so building a lot of like anime nerds and that sort of thing. Nowadays, now we're playing law schools, so we're building a different kind of geek army. And so it was kind of, we were doing national touring quite a bit at the time, and my attorney says, hey, Simon, I think you should apply to register your band's trademark. It's an easy process, it's not very expensive, and in a couple months, the whole thing's gonna be done, so you don't have to worry about it. 2.5 months later, I get the call from him, and he says, hey, we got a problem with your application. I said, what is it? Did I fill out something incorrectly? Because I probably would do something like that. And he says, no, actually everything on it is perfectly fine. But they rejected your name because they said the slants is disparaging to persons of Asian descent. I took a moment, I thought, okay, wait, does disparaging mean what I think it means? And I was like, wait, they're saying we're racist towards Asian people? And he says, yeah. I'm like, wait, do they know we're of Asian descent? You know, we've been a part of our community and working with organizations all across this country. How could they say that? I didn't even know there was a law against this. And he said, yeah, there's something called Section 2A of the Lanham Act, which says that you can't register marks that are considered scandalous, immoral, or disparaging. But it's not disparagement in terms of the general population. Like, you can't survey all Americans and decide what something is disparaging or not. It's only what's considered disparaging to what they call a substantial composite of the reference group. So in this case, Asian Americans, by and large, have to, in a substantial number, consider this thing disparaging. So I said, okay, who did they find who was disparaged? Who did they find that said our name was offensive? And he said, nobody. But they did quote UrbanDictionary.com, and they included photographs of Miley Cyrus pulling her eyes back in a slant-eye gesture.
Oh my God.
And I thought I actually said, you gotta be kidding me. And his response is, no, I'm actually looking at Miley Cyrus right now. It's pretty offensive. And like, I know the photo, I tweeted about this thing. Asian Twitter was all up on that. Like, how could they conflate the two? So he told me, I think they're just off base. They don't understand where you're coming from, so we should go ahead and appeal. And that began a long trajectory. Basically, we followed the pattern of every other 2A appeal on the books. And so the way you kind of appeal a rejection under 2A is that you provide context. You provide evidence showing how your communities or the communities affected are supportive. We got tons of Asian American press. We got executive directors of numerous Asian American organizations involved. And they all signed letters saying, yes, the slants are cool. They work with us. The community loves them. Trademark Office says no, because the Urban Dictionary says this. They quoted Wikipedia, and then they started bringing in an article from MySpace that claimed that one of our concerts at an event called the Asian American Youth Leadership Conference was canceled due to controversy over our name, outrage and complaints. At that point, my attorney calls the examining attorney and says, you know, what's your problem? Like, what's the deal? You obviously, these guys are part of the community. The examining attorney said, honestly, this is coming from above me at this point. If you really want to win, like, you need a couple of things here. You need a national survey. You need to get dictionary experts. You need more legal declarations. And you got to deal with this article that suggests the band's name was so infuriating they had to cancel the concert. My attorneys gave me this checklist and kind of assigned me with all that work. So over the next 6 months, I collected all those things. I got Dr. Ron Butters of Duke University, who worked on another high-profile 2A case, Dykes on Bikes. And he wrote an extensive report on the history of the term slant, showing how it was kind of obscure at best, because most of the time people don't use slant, they use slant-eye when they're talking about kind of a disparaging kind of context, and how over the years it had been reappropriated. We got two professors, one actually here at NYU, who worked on our case in terms of doing an independent national survey, which showed that 92% of Asian Americans supported our use of the name across all generations. Another survey that we didn't commission, done by an Asian newspaper, showed that 98 to 99% of Asian Americans in the Pacific Northwest supported our use of the name. We got the steering committee of the Asian American Youth Leadership Conference to write a legal declaration explaining how our concert was never canceled due to controversy over the name. In fact, they didn't receive a single formal complaint. They canceled it because logistics. They just couldn't have a concert that year. And we gave them photos of me as their keynote the following year and pictures of the band performing in subsequent years. In fact, I've been a workshop facilitator for them for about 4 years and received their Citizen of the Year award. So no question there that they were supporting of us. And then we got more legal declarations and so on and so on. About 2,500 pages of evidence, submitted that. 60 days later, the week of Christmas, I get another email, rejection. USPTO trademark examining attorney decides to step up his game a bit and include a lot more evidence. He started quoting from dictionaries showing how slant is actually a possible offensive slang. The problem is all those dictionaries are from 1938 and 1939. One of them is the British English Dictionary, and they used something called the Racial Slur Database. He dismissed our survey and called that the 1 to 8% of Asian Americans a substantial composite, even though in a previous case, Black Horse versus Pro Football, they said that 30% was not a substantial composite of Native Americans who considered Redskins offensive. Dismissed the dictionary report out of hand, basically dismissed everything that the Asian American community had put forward. Thousands of Asian Americans had put their voices forward. He said it's not good enough, and he continued to rely on urbandictionary.com. At that point, my attorney decides to give up private practice. He was so burnt out of law, so burnt out of the system, he walks away. I get a new attorney because I found someone who blogged about my case, Ron Coleman, who has a site called Likelihood of Confusion. And he says, we need to abandon this application. This is because as long as you're arguing, we're not offensive, you're gonna lose. It's a losing argument. Because the reality is nobody has ever won an appeal on 2A in the entire history of the country. No matter how much evidence they put forward, no matter if they're a part of the community, as long as the examining attorney and members of the trademark office dictated or accused you of being disparaging, whether you actually were or not, there was no way out of it. So he said, I have a different idea. We're gonna submit a new application, one with different specimens, ones that don't actually show that you're Asian American. So we put posters and photographs that depicted really generic concert artwork. The only thing that could show my ethnicity whatsoever is my Chinese middle name. We sent that in, and the trademark office gives us the same examining attorney who copies and pastes his previous response into the new rejection. And my attorney is like, we got him. We got him on a procedural issue because according to the trademark procedural manual, you have to do a fresh search every time a new application comes in. You can't use evidence that predates the application by 2 years. That's a procedural and evidentiary issue. And so we move forward, appealing to the TTAB. We lose there, appealing to the Federal Circuit at a three-panel hearing. We lose there on precedent over a case called McGinley, which basically states, hey, your First Amendment rights are not being violated because you can still use the trademark, you just can't get a registration. But along with that the 5-page decision that was written by Judge Kimberly Moore, came something that was a little unprecedented, a section called Additional Views, which is a 24-page outline of how Section 2A of the Lanham Act is actually unconstitutional and should be revoked. So before we even had a chance to appeal the Federal Circuit decision, they did a sua sponte order to vacate. They decided, oops, we take it back, come back, we're gonna hear this thing en banc with full slate of 12 judges. And that's when I started going to DC, starting to try and get more involved in the case. We the problem from there, from my perspective, was like I couldn't address those evidentiary issues because the court locked the record. They only wanted to hear one question, and it wasn't, is the slants actually disparaging? The question is, does Section 2A of the Lanham Act violate the First Amendment? And so I had to move forward with this locked evidentiary record stating how my band was racist. In fact, the examining attorney, even though he was fully aware that our concert was not canceled due to controversy over our name, that we did all these things with that organization afterwards, he continued to perpetuate the inaccuracies. In fact, so much so that at the federal circuit, he claimed that I was, quote, literally ripped mid-keynote from the podium due to outrage over the audience of our name. Of course, that never happened. I'm still a mentor for those kids today. So that was kind of our track record. 12 judges heard it in January 2015. In October, we get the news that, actually no, it's December. We got the news. In fact, I found out from Twitter because my phone was going off at 6 a.m. and I was like, what is going on? And it's a tweet from Lee Rowland from the ACLU, and it just says, I can't wait for Simon to wake up and see the news. And I'm like, what's the news? What? Check my email. It's my attorney. They just wrote decision as the subject line, and then they sent the attachment. They didn't even tell me. So I'm like digging through this thing, reading through all these papers. I'm like, what? Page 10, page 12, figuring it out. And then I realized, oh my goodness, we actually won. And not just won in a little way, like 9 out of 12 of the judges ruled in our favor, 10, depending on how you're counting. But even 2 of the dissenting judges were like, hey, we don't agree this is a constitutional issue, but the trademark office is really wrong. The slants absolutely should have this. This is political. This is expressive speech. 6 months after that, no trademark registration. The trademark office decides to hold out, defy the federal court orders of kind of reviewing our case, and then instead appeals to the Supreme Court, which of course has granted cert. A whole lot of briefs are filed, including ours, and plus 30 amicus briefs. And then we heard oral arguments in January. At that point, I decided it's really, really important for the justices to see the actual people who they're making decisions about. I think it's really important that they realize it's not just some theoretical case that they read about or see in the news, that they actually see the human beings there. Problem is, I'm a broke musician, so we crowdfund our way there. Fans and supporters generously and graciously donated money so that my entire band could be there. And I think we became maybe the first Supreme Court case that was crowdfunded as well. And we go there, and it was like nothing else, I can tell you that. I mean, for 55 minutes, I get to hear people arguing about me, about my band. I had no chance to say anything because I didn't want to get kicked out of the room. But it was, I think one particular highlight for me was when Justice Ruth Bader Ginsburg said, hey, as she's talking to the Solicitor General, she's like, doesn't it matter that everybody knows the slants are Asian and what they're doing? And he tries to interrupt her, and she's like, shuts him down, says, no, they're removing the sting from the word, which is exactly our work that we're doing. And of course, his only reply was like, well, we found some articles on the internet. I was going to say, like, Urban Dictionary, come on, Urban Dictionary, which, for the record, the printed version of Urban Dictionary doesn't even list slant as a racial slur. But, it's something I needed to get out there. But so that's just kind of been a journey. It's been a journey of a little bit over 8 years and counting. And almost a decade, about a quarter of my life spent on this particular case. Meanwhile, going back and forth between touring, playing rock and roll, trying to make music, working on numerous organizations and that sort of thing. And that's kind of the context, I guess, for our conversation today.
Yeah, no, thank you. I mean, I think the story, your journey, and long journey that hasn't ended yet is you provided a lot of texture, and I think you leave us at like an interesting place where the law, and quite complicated law, comes in. And so I thought it might be interesting to have each of you as lawyers focusing on the First Amendment here, maybe make a case, because there have been so many strands of arguments on the First Amendment here. about what you think the best argument is for unconstitutionality or constitutionality of Section 2A's disparagement provision.
Okay, I'll go first. You know, the ACLU has a really awkward and arm's length relationship to trademark law, right? Because fundamentally a trademark gets to stop other people from using certain words in certain contexts. And so, you know, we acknowledge that copyright and trademark exist for a purpose, which is to make sure that artists can create without other people worried about ripping them off, and in that way, we support it. As long as it has robust fair use defenses and is subject to constitutional scrutiny. So when Simon first came to the ACLU of Oregon, I admit, and I don't think I've said this in public before, and now it's on tape, we did not accept his offer to file an amicus brief on his behalf. And by the way, I was convinced the first time I heard about the case, but I actually had to do some internal advocacy, and it wasn't what you'd think. It wasn't about the racial justice angle and the free speech. It was entirely about us defending trademark registration, which for the ACLU, we'd never done before. For the reason I said, right? We're encouraging more concentration of power over words. But not just Simon's case, but I'm so glad you mentioned Dykes on Bikes. We kind of did a survey of trademark history. And I firmly believed that we had two dogs in this fight that we just could not ignore. The first is that the Supreme Court has time and time again kind of refused to define the line between content and viewpoint discrimination under the First Amendment. So traditionally, if you haven't had much First Amendment law, content discrimination is rarely okay, but it's okay in certain venues that aren't public forum space, like a park or a street or a sidewalk. So if you're in a city council meeting, they can say, hey, stick to the agenda. That's technically telling you what content you can and can't talk about, right? You can't speak about abortion today, that's not on the agenda. There are times when content discrimination is allowed. What's pretty much never allowed is viewpoint discrimination, which is nobody can talk about abortion today if they're pro-choice. Right? So it's only one certain viewpoint or opinion about life. And we took a firm look at 2A, and we believe that 2A is a viewpoint discrimination mechanism. Because by saying you only can't disparage people, it is a type of negative speech, whereas positive speech is allowed. Right? So you can compliment a politician. You can say, go Yanks, but you can't say Yankees suck. Right? You can say, I love the federal government, but you can't say, end the Fed. And I use those examples intentionally because disparagement does not say disparagement of a natural person. It says disparagement of any person, group, or institution. So literally, end the Fed is technically, I think, disparaging under 2A. Now, it's never held that way. Of course, it's only applied in kind of controversial cases, and I'm definitely using air quotes because I think the slants deserve their trademark. But that's really one huge interest of ours. Is this content or viewpoint? We believe it's viewpoint. There's only one Supreme Court case where the court's gotten close to this question. It was a 3-judge vote in a terrible O'Connor case, so it's not a surprise. But it's it's true. Her opinions are mush. They're just terrible. My apologies if you have to weed whack through them. But basically it said, it was a rule that banned protesting in front of consular offices in a way that might bring the foreign country into disrepute. And 3 judges on the court said, well, maybe that's content rather than viewpoint, because it doesn't matter whether you call into, disrepute Israel or Palestine. So that's not a viewpoint, right? It's just we want to have nice things, right? It's just everybody has to be positive all the time. We disagree with that. I will tell you, however, that there is one person in the world who makes this argument very difficult, and she considers herself a free speech advocate, but she definitely is ruining First Amendment law, and that's Pam Geller. I don't know if you guys know her. This is a woman who routinely tries to place pretty virulently anti-Islam messages in public spaces. So she wants to put them up in the New York subway, in the DC subway. I think at least 3 metropolitan areas have changed their rules for posting on government property, specifically because of Pam Geller's attempts to get really racist ads put up. So That's the first thing, is we kind of couldn't walk away from this, that we think this is viewpoint discrimination, and that's never okay by the government, full stop. It's actually not hard at all. Doctrinally, this is First Amendment 101. You can't do it. The government can't offer you a benefit and say, well, you only get this benefit if you think X way. It's literally the first thing you would learn in your first class in First Amendment law, so we kind of can't let that go. The second is just, in addition to the breadth of the phrase, is its ridiculous vagueness. So Simon mentioned Dykes on Bikes. You might be familiar with the band NWA, who probably benefited from the fact that Google was not readily available when they trademarked their name. There is a magazine called Heeb magazine that was started by Jewish people. Heeb is occasionally known as a slur for Jewish people. So the only difference we could see in the law is that people with money who had the ability to file an appeal every once in a while could fight through, but there was this unbelievably hilarious evidence that the exact same term had been submitted 20 times, accepted 10, and rejected 10. You could not, with a straight face, look at the history of trademark registration denials and admissions and say that there is any logic to it. It's whatever the individual examiner and his access to Urban Dictionary determine on an ad hoc basis is going to offend some group of theoretical people that they've decided to take on, right? And I do think there is a paternalism and a philosophical weirdness to a white dude in the PTO office deciding, I have decided some substantial composite, whatever that vague term means, of Asians, whatever that term means, again to him, would be offended. It is not his place as a government actor to be making that call. And the last thing I would note as far as the kind of interest here and why we think it really is pernicious is that this is the government playing language police and distributing benefits based on whether they think you're nice enough, but also it's a one-way ratchet, which is just bizarre. So the Redskins, who got their trademark in the 1970s, have made billions of dollars off it. Now, arguably, that word has become more offensive in the general, right? In the kind of general understanding, I'm uncomfortable saying that word. I generally say the Washington football team, if I can avoid it. Which everybody knows, by the way, but there is a hilarity to it because, like, I talk to people who are season ticket holders, right? I mean, so we have this very weird relationship to that word. But in that situation, they would have had to guess that 40 years later, language would have evolved in such a way that people are more concerned about using that word, right? It talks about someone's skin color, literally, right? Whereas Simon doesn't have the opposite right. He can never reclaim language. He can never take the sting out of it under these rules and evolve it and reclaim it and reappropriate it because it's offensive now in the eyes of the PTO. So what it does is it freezes language in all time in this very bizarre way moving forward where you might theoretically have a trademark removed even if it wasn't offensive at the time you registered, which I think requires a trademark register to be a little bit psychic, right? Where are we going to head as a society? What's going to offend people in 40 years? And the problem with that is chill and self-censorship, and that is the other core ACLU issue. Simon is nuts for picking a name that caused you 10 years of pain, right? I'm so glad you did it. We all owe you a huge debt of gratitude for being a constitutional advocate in addition to your rock star duties. It's awesome. But most people don't have the resources, don't have the money to put up a fight over just registering their name. So they're probably gonna pick the rainbows and puppies rather than something like the slants. And I think that impoverishes our culture and our language to have everybody feel like, I have to be a completely offenseless automaton to make it through this incoherent maze of the PTO. And that's not a role our government should be playing, and that's why we weighed in on the case. That's plenty, I think, for me to start with.
Yeah, so Cecilia, I know you take the opposite view, so what do you think?
Right, so I'm not sure it's exactly the opposite view. I'm not a First Amendment attorney. I work for an Asian American civil rights organization in DC. And when I first started my job, this was one of the cases that everyone wanted to talk to me about. I don't know much about trademarks, right? My natural instinct is pro-First Amendment. And some of my exposure to this case is sitting across the table from people who are honestly probably more of my parents' generation. But they told me stories about, for example, which is, I just actually can't comprehend it, so I had to hear them tell me these stories about being in elementary school and walking into a classroom as the only Asian child, and everyone else in that classroom had taped their eyes back. And that's how they had to go to class that morning. And that was just one story. I also heard from people that know Simon's band, that totally support the fight to reappropriate stance, that just get it. And they, those two groups of people were having a hard time talking to each other. And it was almost like, they were just coming from different worlds, and there was no way to mediate those experiences. But that's what, I confronted as an attorney trying to represent everyone in the community and how to deal with this case, which was already at the Supreme Court by the time I joined my organization. So what we did is we actually filed one of the 30 amicus briefs. It was in support of neither side, and many of the amicus briefs in this case took that view, which is interesting for Supreme Court litigation. And again, not being First Amendment attorneys, what we wanted the court to know is, one, that there is harm in the world from these words. They do actually harm communities, vulnerable communities. The Fed Circuit ruling, if it were upheld, because it facially invalidated the provision of the Lanham Act that bars disparaging marks. So people asked, would that mean that you can register the N-word? Would it mean that you can register Native American symbols that those communities feel are their cultural heritage, but are now being used by sports teams or by other merchandise in really offensive ways? One of the examples, which I actually wrote about in a blog post, was the Washington Redskins sells thong underwear with the Redskins logo. With the Chief logo, the people view as like their heritage. They sell that for profit on their website, and so people are offended. And I think, wherever you are in the First Amendment, you can kind of understand that reaction if a sacred symbol was being used in that way. So trademark law is complicated, like Lee said. It's this complicated system we set up. It does benefit artists, that's for sure, but it also benefits big billion-dollar businesses that want that mark to stop speech. I mean, that's literally what they're doing, right? That's why it's valuable to them. So it's weird to talk about the First Amendment in this context because it's just a complicated system. So, our position is that maybe there should be, and again, this is not even from the First Amendment context, it's really just speaking from where the community is and from where Asian American groups are. Maybe there should be a narrow solution that recognizes the specialness of what Simon and his band are trying to do. They're performers, they come from the community, they're trying to reappropriate a word, and they have good evidence, which may or may not be in the record, of how the community actually views their band. But those are factors that are very different from someone like the Redskins, or from someone like Pam Geller's group trying to trademark, terminology that targets Muslims, or and there might be a narrower remedy, which is what we suggested to the court, than facially invalidating a provision of this complicated law, which stops as much speech as it promotes speech, and one that really, harms, I think, vulnerable communities in a way that pits the sort of civil rights against the First Amendment in a way that may be overbroad. And just a final question, which we had in our brief, but I'll sort of leave with you guys, is we do believe in reappropriation. That's been a powerful trope in the civil rights community. But who should those words belong to, right? That's just a complicated question, both policy-wise and constitutionally and under the First Amendment. Trademark law doesn't give, it's not a particularly democratic field. It gives the party that registers the mark, that uses it first, that seeks the registration, ownership of that word. It's literally a form of owning property. And aren't there some words, either because of reappropriation or because of their cultural symbolism, that shouldn't be owned by anyone? And isn't that maybe sort of core to what we normally understand as the First Amendment? And shouldn't that be important in a world where, even if we're talking about the marketplace of ideas and just not the marketplace of profiting over people's cultural symbols, where not everyone has equal access to the microphone or to the stage or to the papers? It costs a lot of money to do a successful trademark application, but also costs a lot of money, if you're one of the groups that are in the minority trying to reclaim that word to get as much public attention or space. So, I think the Supreme Court is sometimes not great with questions that don't have easy answers. Its First Amendment jurisprudence is often putting things in little boxes, right? So is it content, is it viewpoint, is it this or is it that? And sadly for us, we wanted the court to know that you shouldn't pit civil rights against the First Amendment, but in too many contexts, like hate speech, and other things. They're really picking remedies that aren't taking into account, I think, the full impact and hurt of the rule, and thinking maybe of solutions perhaps broader than sometimes the case presents itself, which really balance the needs of sort of all the groups in a sensible way. And so that's how we got involved and why we sort of filed a brief that I will say is actually pretty much in line with what Lee and Simon said, and doesn't contradict their arguments in any way.
Well, I mean, I think that's a good segue to raise the following question, particularly for Simon and Lee. Okay, so assume the slants win, and you win, you get your trademark registration for slants for entertainment services. That means that a racist, anti-Asian group can go register the slants for other things, not for in any way that will be confusing anymore, but for something else. Or frankly, let's take the Washington football team example. Are you okay? How do you feel about racist groups or commercial groups that are not connected to this sort of reappropriation, reclaiming of these words, getting trademark rights?
Well, there's a couple of things there to unpack. Number one earns trademark rights whether or not they have a registration. It's through use. So people can theoretically have trademark rights for the most despicable of things, whether or not they have the registration. Number two, those things are already being registered. I can't tell you how many emails I get from the KKK, from other white supremacist groups who brag that they can register slant, but I can't. Because when we asked the trademark office, I said, hold on a second, slant means many, many different things. Why in this case? Why is a case of the band that the term became disparaging when I'm the only person in all of U.S. history to be denied a registration for the term slant? They registered it dozens and dozens of times. The trademark office said it is incontestable that the applicant is of Asian descent and part of an Asian band. Therefore, the context is provided for disparagement. You see, in their mind, if people go to a rock concert by a band called The Slants, because our mark is for live performances by a musical band, and they see a bunch of Asian people on stage, they're going to automatically think of racial slur instead of any other possible definition that they've ever traditionally used the word slant in. Therefore, it's a very convoluted way of saying basically anyone can register a trademark for the slants as long as they're not Asian. My own identity was used against me in the kind of fight against racism. And the reason why I've kind of, I guess, become a little bit more comfortable with the notion that there's a possibility of other people using hate speech and that sort of thing, because number one, I don't think that the moral line in the sand should be drawn at the trademark office. I think there are better vehicles to address racism than trademark registrations. But number two, what we found over the years is that the law they're using, while it is noble in its purpose, is disproportionately used against communities of color and members of the LGBTQ community because those are precisely the groups that engage in the work of reappropriation and therefore prime targets to have their own identities used against them. Whether it is an Asian group trying to register the slants, a pro-lesbian group called Dykes on Bikes, or anyone else, that we've seen this happen over and over again. There's an amazing feminist rock band from Seattle that was recently denied called Thunder Pussy. There was a man who had to declare bankruptcy for his t-shirt company. He was an Asian American activist, Randall Liu, who had these t-shirts that say "Chink Proud." And he's like, I hope you win, because I got a garage full of shirts I'm trying to get rid of. And so I think what happens is it's like impulsive. Our natural inclination is like, yes, we don't want the Dan Snyders of the world to win. Absolutely not. But we shouldn't be so obsessed with punishing villainous characters like Dan Snyder. We're willing to accept that the collateral damage is actually bared by marginalized groups who are trying to make their way forward, who are trying to engage in these things. And yes, it's true, trademarks limit speech, but only in a very narrow commercial aspect, a particular product or service or good that's identified. It's not like if I register the slants, nobody in America could register a trademark for the slants anymore. No, the reality is that there's about 800 trademarks for slant right now. So that's why I've kind of become a little bit more comfortable with that notion. And I think it's taken me a while, to be honest with you. For many years, I thought, okay, Maybe the trademark office should have a kind of certain category, like provide more context, provide more evidence. But I've learned very quickly that kind of method is actually very regressive in nature. You're basically asking burdened communities to place additional burdens on themselves by registering and going through this very, very long legal process, very expensive legal process, and navigating your way through that. And I realized that because of that, I kind of started shifting my own perspective into probably closer in line with that of the ACLU, which is that the cure for bad speech isn't censorship. It's better speech. It's more nuanced speech. And that means providing a path forward for groups who are targeted by laws that can inadvertently use people's identities against them. It's very much my line of thinking of kind of Martin Luther King Jr.'s quote that an injustice anywhere is a threat to justice everywhere. And for me, the federal government having this unfettered right to deny people's benefits based on their race, that doesn't sit well with me. And that's why I chose to fight this thing for so many years. And that's why I was like, I'm willing to pay this cost. Yes, they're real costs, because apparently there's something called appellate printing that nobody told me about in advance. That stuff is not cool. Paying every single time we respond to the trademark office, paying for logistics, paying by sacrificing my own arts career so that I could proceed forward with changing this law, and paying the price of being accused of helping a racist football team get their trademarks back. That's all part of that cost, but if it leads to social change and a more nuanced law that can hopefully accommodate those views of marginalized groups, then hey, I'm all for it.
I can't answer much better than that, Simon. We should have a job opening for you. But the speaker-based discrimination is real. I just want to emphasize that, right? They Googled Simon, and then they said, oh, no dice for these guys, right? And there is such a paternalism in that, such a patriarchy. I'm so uncomfortable with a system. And I actually I'm willing to go as far as to say this. I actually think an as-applied ruling saying that Simon has a special right to reappropriate, but that groups like the Redskins don't, would be worse than you guys losing your case and getting it overturned. And the reason is, I just don't believe systems like that work. That would require some system that assigns rights based on identity. I, number one, certainly don't trust the PTO to get that right, okay? But number two, none of us should fool ourselves and think that corporations aren't gonna jerry-rig that system. Do you know how many Native Americans are on the Washington football team's payroll to tell people that their name is not offensive? Several, okay? So don't tell me they couldn't figure out a way to get in front of the PTO and say, here are exhibit A through Z, Native American chiefs who will tell you why our team name is not offensive, and don't tell me the PTO won't buy it. And you know, the DC Circuit has, it's Judge Collar-Cotelli, she's on the district court, has a 50-page opinion in an older case about the Redskins called Harjo, where she literally takes 30 pages to woman-splain her way through the fact that Redskins cannot possibly be offensive to a substantial composite because their sales are good. It is one of the most racially offensive opinions I have ever read. And that's what I worry about, is that I really believe the status quo, the power structures, will find a way. If we assign rights based on identity, the very people we don't want to do that will have the power and ability to make that system work for them. I think it will still hurt people like Dykes on bikes and slants. I think those people are still gonna have to fight for every breadcrumb because they don't have a natural audience at the PTO. So that is actually the solution I'm least comfortable with. All that being said, my God, I'm glad that it's you guys at the Supreme Court instead of the Washington football team. They did actually move to intervene and try to get into the case at the Supreme Court, and I was sweating bullets. Because the only way we lose this case, you're gonna win this case, Simon. The only way we lose it is if there's enough liberal guilt over the outcome. And the team tried to make that happen, and thank God they failed. Because if you guys are familiar with a case called Walker versus Texas Division of the Sons of Confederate Veterans, it's a case where the liberal bloc on the court ruled that a specialty license plate given to a Confederate group was government speech. That is a factually unsupportable conclusion. It just is. But the reason they twisted themselves in knots to get there is because they didn't want a license plate driving around Texas with a Confederate flag on it. And I'm very sympathetic to why. I really am. We filed a brief on the other side in that case. That, for me, was much harder and more controversial than anything in this particular set of cases. But that was clearly not a First Amendment outcome. That was a we're really uncomfortable with racist speech outcome. And I'm so much happier that if we're going to have a First Amendment win here, you guys are going to be the vanguard of that, because I think it does nicely highlight the ridiculousness of this rule and how it actually hurts people of color, people challenging the status quo, people trying to evolve our language.
Well, I mean, that leads me to one more question I want to ask before opening this up to Q&A, and it kind of gets into the weeds of both trademark law and First Amendment, but it hasn't really come up other than you starting to reference the license plate case. I mean, one of the big arguments that the government made to the Supreme Court is, well, we shouldn't be analyzing this based on viewpoint discrimination, content-based discrimination, but we ought to be thinking about this as a government subsidy. And in that case, it's much easier,
Right.
to survive the First Amendment scrutiny that comes along with it. What do you say to that? I mean, is that the right analysis here? Is that how we ought to see? And I think, Simon, you mentioned before that trademark law doesn't require you to register a mark in order to have common law rights in it. And that's entirely correct, although there still is some open question about whether a mark has to be registrable to be protected. And so that's another tough question. But then so much of, the related to whether this is a government program or a government subsidy is whether trademark registration is necessary or quite important in order to use the mark, if you can have common law rights without it. And so I was wondering if, you had any thoughts on this vein of argument and the Supreme Court's receptiveness to that.
Really quickly, I just think it's crazy weak in this case. I mean, I think in Walker, even though we filed on the other side, I, as a human, can understand that seeing a Confederate flag license plate driving around Texas, like your average viewer might be like, hey, did the government do that, right? There's a history there that at least might make some people ask the question. Nobody goes up to a shelf and is like, Saratoga TM, fresh from the United States government. It's just not credible. It's not credible. And there are several parts of the test in Walker. One is reasonable observer. One is the kind of government purpose behind it. And the government has sworn up and down, including in a case named Old Glory Condom Corporation, that they do not endorse speech when they offer a trademark. And that's obvious, right? And the name of the condom case tells you why. So not only do they meet none of the four tests, the government has aggressively and repeatedly asserted this is not government speech. They tried to dial it back to the kind of registration as a government benefit where they have more. And that, I think, is the most pernicious argument in this case, and I'm embarrassed for the Solicitor General, because under that argument, the mere writing down, the mere recording of a list of people would give the government authority to engage in viewpoint discrimination. So guess what? Let's hope you never apply for a parade permit or ask if you can have a permit for a public park or a gun license, because all of those things, the government then has to write down who you are and why you want it. And if that is a government benefit, we're doomed. It means when you call them to ask for the fire department to be sent out, first they can ask you if you voted for Trump, then they decide whether or not they send the fire truck. It's not a viable argument.
Can I just say?
Of course.
So I'm maybe going to try to defend the benefit of liberal guilt.
Good.
So, well, I think these things are rooted in history, and weighing of harms or figuring out, sort of predicting what's going to happen in the future is difficult. But one question to ask is, if you don't trust the government, right, and I think it's very hard to defend some of the arbitrary actions that have happened in considering trademark registration applications, is why do we trust them to run this trademark system, period? What's the purpose of the system? And why is the government intervening in the marketplace and helping people make millions of dollars? So I guess, just one thing to consider is you're looking at one provision of the Lanham Act and leaving everything else in place, right? Including the provisions of the Lanham Act that allow people that already hold trademarks. So one example we gave in our amicus brief is a university with a chieftain logo that they've trademarked sending cease and desist letters to student activists who are trying to reuse that trademark, right? So the Supreme Court ruling on this narrow provision, which is the protection for minority communities, isn't going to address that. And so what is the world going to look like when it's taken away? You know, the playing field won't necessarily be even. It's taken away one protection in this balanced statutory scheme, but left in place, or maybe just not addressed, the other provisions of the Lanham Act that really do chill speech or make a difference. So, you know, again, it's hard, I think, sometimes to defend some of the issues in this case from the government's perspective. I agree, some of their arguments aren't very compelling. But in thinking about the remedy, let's look at what the world is going to look like. So if you care about first speech in the trademark context, let's care about it seriously and not just leave in place the rest of the system, because I think it's right. It disadvantages people with less money and less power, but it disadvantages them in a really profound way in a world where the people with more money and more power have already gotten their trademarks, and those are going to be left in place, no matter what harm they actually have in the real world.
I think that's a really important point, Cecilia, because and obviously we're looking at it through the lens of Simon, who I think on a gut level we realize is doing something that we consider a positive social justice, you know? But if you look at the Washington football team, as to what you just said, it literally means that if a Native American group, right, decided that they wanted the name Redskins, then the team gets to sue them for infringement, right? And I think that makes us all feel a little gross. So if you don't look into intent, it does mean that people with power and status quo can grab onto that word first and then keep everybody away. And that is really why we initially struggled with the case, exactly that reason. We've kind of taken refuge in the fair use area, which is to say you might not have a right to profit off of that, but you certainly have a right to engage in immense criticism, parody, and I'm not sure, I think that's still half a loaf, but at least for us, that's kind of where we're trying to push back on that idea that there was a recent case, for example, of somebody using the NAACP's trademark as an anti-abortion ad, National Organization for the Advancement of Abortion of Colored People, right? That making fun of NAACP for not being anti-choice. And we cited that case and said in cases like this, where there's strong disagreement over a matter of public policy, the thumb always goes on the scale of fair use. So I think that's an area where we would suggest if you did get a Native team trying to elevate this as a public issue, we would put every egg in their basket of saying they have the First Amendment right to challenge that status quo. But I admit it's not perfect, and I think that is the strongest argument against this, is that you are allowing those powers to grab onto those words. And if you have a disadvantaged minority, it's going to be hard for them to not be infringing, right?
Yeah, unfortunately, that wasn't even one of the arguments that the government really pushed forward. They tried to convince everybody that it was government speech, that the mere act of registering a mark is the government speaking, which of course is, I think most people thought it was pretty funny, especially if you read some of the briefs that were filed, notably that of the Cato Institute, which basically has a list of really, really offensive stuff that have been considered, that are registered trademarks now. Things like take your panties off, MILF hunter, murder for hire, things that they're like, did the government speak these things? And if so, then we got a lot of other issues. And, you know, I think people also forget that while the USPTO and the government might be feeling high and mighty about the Washington football team, they kind of like hide the fact that they actually registered another trademark for Redskin in 2014 for a company called My Dad's Cool Nuts Company, which is full of scandalous, immoral, and disparaging things. The government doesn't say, oh, no problems there. In fact, the week that we went to the Supreme Court, they issued another registration for Slant to somebody else in the Northwest. You know, as an Asian American, number one, there's also more colorful words that people choose to address my community, to disparage my community, but every single one of those words is a registered trademark right now. So it's a really complex system and situation.
Okay, so why don't we open up the floor to some questions. Just make sure you get to the mic because this is being videotaped to ask your question, or it will be brought to you. Yeah. Question.
Hi, thank you guys for speaking with us today. So as you guys were talking, I could hear a lot of like interdisciplinary type terms and comments coming in. Even in some of the discussion that we were having here was harping on a lot of sociocultural theories on sort of like racism, appropriation, and sort of social boundaries and sort of that type of language. I know the court isn't, especially in your case, it doesn't seem like it had been favorable to sort of like, I don't know, some of those type of commentary, or maybe even scholars who are sort of already doing a lot of this work have already put like studies and research and books like Michelle Lamont and Swidler and stuff have sort of talked about the benefit of reappropriating these terms. How have you crafted some of that general language that you guys are using here into more legal arguments, and has that been helpful or effective in any of the work you're doing or in your case in sort of bringing forth more positive and also like equitable outcomes in the court?
I can answer. I just didn't know if you wanted to start, Simon. I mean, I'm a free speech attorney at what I think is broadly considered a progressive organization. And I think I routinely have the job of doing what is very much not progressive work within the broader ACLU. And while, by the way, some people take issue with this, especially in the free speech community, I do feel like one of my jobs is to break down what is often a false dichotomy between free speech and civil rights. And I totally agree with what Cecilia said, and actually I think their brief is really beautiful on that score, right? To not kind of do this false tension. And I've been thinking about it a lot. Part of what I like to remind people is that a lot of our high watermarks for free speech were forged in the civil rights era, right? Incitement, NAACP v. Claiborne, right? Like, it's not incitement for Charles Evers to give an impassioned speech, right? And there are many other examples that are really important. And so I think about it more that way, which is we want the First Amendment outcome, but not because we have our heads buried in the sand that sometimes that is pernicious or that causes harm or offense, and people may legitimately feel attacked, when they see a product that is tapping into some of these experiences that Cecilia talked about. Like, that's legitimately horrifying, and I don't like saying that free speech is costless. It's not. So when we use it in legal language, it's more about, I'll admit here, I think the most powerful thing in this case is simply giving a long list of all the trademarks they've granted and denied on the same word. It just feels like such a QED. So I wouldn't say we had the most philosophical brief, but I do think that the slants as the appellee here gives you the opportunity to tell the court the philosophy of this is fundamentally wrong, right? The philosophy of putting this job in government's hands, this is how it's backfiring. Because the only way you really reach a conclusion that this is wrong is because you want to ensure that minorities aren't oppressed, right? That vulnerable people don't see that reflected back at them in the marketplace. But this case shows that that's not a correct assumption about how the system is shaking out, right? And so I'm not Pollyannish about it. Sometimes it shakes out the other way for the Washington football team, exactly what Cecilia was just saying about the kind of initial stranglehold. But I think it's so important to the court to understand, especially the liberals on the court, that they're, I think, very good-hearted instincts of having a system that doesn't repenalize people based on race might just be philosophically flawed because it doesn't give breathing room to evolve language and that kind of stuff. So that's all in our brief. But I would be lying if I didn't say we also, like the Cato Institute, had some fun with the fact that you just look at this thing and there's no government interest effectuated. You just can't say that with a straight face. So I think that's the most powerful legal argument. But in terms of reappropriation, I think it's more about the optics of convincing the Sotomayor to, God, I have to be on this opinion with Alito, right? Because that's where she's going to be. So that's why I think that rhetoric is important to tell them. You're not being a bad ally, right? You're not harming the cause of racial justice by ruling for the First Amendment here. Actually, you're supporting both. I think that's the rhetoric we try and get in the case law. And that would be a hell of a lot harder if this was a brief for the football team, as you might imagine.
Hi, I have a question for Ms. Rowland. So you mentioned that there's a viewpoint discrimination issue here because it disallows a trademark for disparaging terms, but not terms that are, I guess, positive. But as in this case, you can use a potentially disparaging term without being disparaging.
Absolutely.
You can also use a positive term while being disparaging. Like suppose you have a band called Whites Are Best, or that's my creative
I'm not sure I'd listen to you or buy the album, but that's a great example.
But I'm just so it makes me wonder how does the viewpoint discrimination like play into the wider dynamic? Because like language is a really, people can play with language in various ways. So for me, in the end, it really just depends on that one guy sitting behind a desk
Yeah.
and his feeling on that day.
Well, I totally agree with you. I mean, and I really think, at least in this case, it is, you know, one of the reasons I think Simon's attorneys have rightly chosen at least to press the as-applied claim is for exactly that reason. That rather than say Simon gets a special right because he's Asian, to use this word, it's not that. It's that, hey, in their case, it's not disparaging. So under the terms of the statute, you know, we don't fit. And I understand why they're making that argument. That's the right argument for them to make. The problem for me is that I worry that argument then devolves into the kind of speaker-based test, like who are you, what's in your heart and mind? And that's where I feel like we're making the government more invasive than it already is in this, you know, where they're urban dictionarying or Googling this, you know, the band members. Now, it's not only that, but like, what's your racial identity? Do you have cred in your community? That's just stuff that gives me the hives when I start thinking about a dude at the PTO engaging in that kind of inquiry. So, I mean, that's all I would say is that I do think disparaging is not only viewpoint-based, but it's inherently vague for exactly that reason. And the only person on the court that seems to kind of disagree with that outlook is Justice Breyer, who just repeatedly kept asking these unbelievably convoluted hypotheticals that I think all boil down to the phrase, why can't we have nice things? Why can't we have nice things? Why can't we just pretend disparaging is content? Because we all just want a nice world, you know, like sunshine and rainbows. And it just agonizes him that really the First Amendment does mean if the government's going to offer benefits, if it's going to profit off of stuff, sometimes it's going to be ugly because the market is ugly, because humans are ugly, and we're not doing anything to fix societal problems by pretending none of those things are true. But Breyer disagrees.
Hi, so first off, thank you so much for speaking with us. This has been really great. You know, sort of following up on that, I think there's this running theme through this talk so far that, you know, maybe the government and USPTO in particular shouldn't be the ones who are making that call, right, about whether something is disparaging or whether these are the right people saying it. So, you know, at the risk of sounding too academic, in your minds, and you represent various viewpoints, like who's the right person to make that call, or should it be no one and just a matter of public opinion?
Yeah, to me, one of the things that we pressed forward from early on is this broader point, and I wouldn't say it's necessarily a legal one, but ultimately it should be the communities that are most affected. They should have the right to determine what's best for themselves. How you write a law around that, I have no idea, especially when you consider my community, Asian Americans, right? We're not a monolithic group. We're comprised of many, many different languages, cultures, unique histories and experiences, and it further gets even more unique, and when you consider like people if they're first or second or third generation immigrants who, you know, there's a lot of intersectionality there that needs to be considered. So I don't know if there's a path forward in terms of the law. I just, as an activist, like, don't put that in the hands of the government. I mean, to kind of give you an example of this, we actually had a Oregon Commission Board of Asian American Leaders called OCAPIA, the Oregon Commission of Asian Pacific Islander Affairs, who sent a letter to the trademark office back in our first application, and they said, well, who did you speak with? Which Asian American organizations are you working with to say slants are disparaging? Trademark office wrote back and said nobody. So, but we are a very diverse organization. We have up to 30% people of color working in our office, and even more around Washington, D.C. Their response is basically like, hey, yo, Kevin's a Chinese dude. He works in the corner around for me. I understand his racial experience. I know this guy down the street. Sometimes I go visit the Korean market. Like, no, that's not how these things work. Because it tends to be that people are blinded by privilege in their own experiences, and it doesn't even have to be intentional. They can have the most noble of intentions, but because of that presumption of knowing other people's experiences, I don't know if anybody at the government or any one community group can really make that decision for other individuals and how they might feel and whether they consider something disparaging or not.
I don't know if this is actually within the scope of your question, but I think it does belong to the community. And no matter how the Supreme Court decides this case, all of you still have a responsibility, right? You have the power of the pocketbook. You have the power of social media. Just because someone has a trademark doesn't mean that it's good, that you should support their business, or that like there's any like value judgment that comes with that. So, that doesn't end the debate. If you want to reappropriate a word, if you care about this, if you think it's interesting, you need to go and mobilize. I'm not sure anyone needs to put in as much time and effort as Simon, but
Please don't.
it's important. I mean, I've said this to my own, to the people in my own community. If you really care about this, then you should go and do something about it. And you don't need to, I don't believe in waiting for the government to go first for sure, right? You don't need to wait for even that trademark issue to arise or for them to make a decision. You all have the power to take action because ultimately trademark is about commerce and business and even artistic performance is about audience, right? And you are the audience, you are the market. So it's the people, everyday people, and the affected communities that ultimately should have the power to move on these issues and ultimately should be speaking up if they feel powerfully about it.
Okay, we have time for one last question.
Hi, thanks for giving this talk. This has been really interesting. I'm curious because one sticking point seems to be, I mean, you said, you could just have a brief listing all the names that they've granted that are offensive. So I'm curious, hypothetically, if they were to come up with some sort of new standard where they still did not allow disparaging marks, but there was some sort of hypothetical perfect rule where they could have a more stringent way of determining what's offensive and not offensive. Do you, in theory, support the idea of the trademark office not allowing disparaging marks, or do you just flat out that in general you don't think that's a good idea?
The latter, with one asterisk, which I would say that I think there are existing categories in the Lanham Act that I do think of as content rather than viewpoint. For example, no use of a private person's real name without their consent, right? And I don't think that's about viewpoint, about your opinion. I think that's like they can't trademark like Lee Roland cornflakes without calling me or whatever, which seems right? Cornflakes are so milquetoast compared to anything I could have assigned myself a trademark for. Anyway, but my concern is, and this is something we grapple with, that we're really grappling with in the subway ads. And that's why I mentioned it at the beginning. So the ACLU has a new campaign that we have printed the First Amendment in Spanish and Arabic, and it's showing in Times Square. And I actually went to see it. It's kind of cool. It's just cool to see it in Times Square. Weird, flashy place for a constitutional law message. And the reason it's in Times Square is because we are not eligible to put the text of the First Amendment up in the New York City subways because of their reaction to Pam Geller. And they have now attempted to define controversy in a way that is content rather than viewpoint. And to do that, and this gets into some of Cecilia's more philosophical points about capitalism, they've actually come up with a system that's like, well, it has to be for profit, you have to be selling something, and you can't basically, and this is both DC and New York, you can't attempt to influence people on a matter of public policy on which there are varying opinions. That is the actual text of the rule. So it's basically like you can't petition any, you can't associate or petition anyone. Like there's something very fundamentally wrong with that. And that has been their attempt to get to an end result where they can tell Pamela Geller no. And what it does is we allow that to just fundamentally impoverish our discourse. And trust me, I think Pamela Geller is a hateful person. I think her ads are disgusting. But when the government offers an opportunity for profit, right, whether it's a registered mark or whether it's an advertisement in the subway, if they attempt to offer that only on non-controversial terms, we get, I think, into a very weirder philosophical place with the only thing that's not controversial is capitalist attempts to sell you shit. And I have to admit, I am not comfortable with that outcome. I would rather have us be offended and be able to respond to it. And by the way, there have been incredible group activism in cities where Pam Geller has gotten her ads placed that I think has actually moved the conversation forward, as opposed to now we literally cannot put up the text of the First Amendment in the New York City subway system. That can't be the right result. And I think when you get the government trying to avoid controversy but they can't do that viewpoint thing, they end up swallowing so much speech that, there's not much free left in that speech. And I'm not smart enough to think of a way to get that result, to get the Pam Gellers out of the world without getting rid of the text of the First Amendment, and that's not a trade-off I'm willing to make.
Any other final thoughts?
I mean, I think you have to leave room for debate, because if you just try and shut people down, then we don't actually move forward. And, treating these things as uncomfortable as it may be, dealing with racial slurs, the reality is that people of color, their biggest challenges in life don't come from dealing with racial slurs. They come with dealing with a racist society of institutionalized and systemic racism that is embedded in every area of our law. If you think about it like a convoluted way to approach that, I think that the powers that be are coming from a much different experience, are going to find ways to target vulnerable communities once more. In many ways, you think about the laws that were here, like a stop and frisk policy. They're like, hey, we're just trying to provide safety. We're trying to do nice things. But who ends up being the target of those things? Not people who share the same privileges and wealth and experiences of those writing the laws, but very differently, the communities that are struggling. And that's why I think we need to allow room for debate, because things like parody and satire and wit, these are things that are essential for our democracy, and they're tools that ultimately neuter malice.
Verbal purity is not social change. It doesn't help us to neuter the conversation. It just hinders us.
So one last word before we end and thank our panelists. You've seen Simon as an activist. If you want to see him as an artist with his band, The Slants, one other member who's here today.
Joe?
Come see them this evening down the block on McDougal Street at Cafe Y. I think the doors open 6:30.
7
show at
p.m.
7?
Yeah.
Okay.
And it ends early, so you can, if you got finals or whatever, it's cool. I think we're playing 7:30 to 8:30 tonight. So.
And if you can't make it, we have a tiny desk concert at the ACLU tomorrow, so that will be on the ACLU's Facebook feed as well.
Awesome. Well, please join me in thanking our panelists.